The first serious dispute over the moon will begin with a machine touching dust. A robotic lander will reach a polar crater and identify ice beneath the regolith. Its sponsoring state will describe the mission as peaceful exploration. The company operating the vehicle will describe the ice as an economic resource. Nearby powers will study the same crater through orbital sensors. Each actor will understand the strategic meaning. Water on the moon can support life. It can also become oxygen for breathing and hydrogen for fuel. A deposit near a useful landing zone therefore carries economic weight and military value. This is where lunar law becomes a contest over power. The Outer Space Treaty supplies the basic legal foundation. Article 2 reserves the moon for common access by placing sovereignty beyond the accepted framework. Article 6 places responsibility for private activity upon states. Article 9 requires due regard for the interests of other parties. These provisions created a broad order for an era of flags and brief expeditions. They now face an era built around extraction and permanent presence. The central legal question concerns the difference between territory and material. A state may accept that the lunar surface remains beyond sovereign ownership while granting a company title to resources after extraction. American law follows that model. The Commercial Space Launch Competitiveness Act recognizes rights in resources obtained by American citizens, while presenting those rights as consistent with national treaty obligations. The statute separates ownership of recovered material from ownership of the celestial body itself. That distinction appears clean on paper. Physical operations will make it harder. A mining vehicle requires room to work. It requires reliable access to power. It also needs safe landing corridors. The operator will seek a controlled area around the site. Lawyers may call this a safety zone. Engineers may call it mission assurance. Strategists will recognize a territorial effect. The Artemis Accords place this idea within a diplomatic framework. Signatories support resource extraction and propose coordination around activities that could create harmful interference. The language favors transparency and communication. The practical result could resemble a managed perimeter around a valuable site. A safety zone can begin as a technical measure and mature into political authority. Consider a crater containing accessible ice. The first operator installs power systems near the rim because sunlight remains available for long periods. It places a processing unit near the deposit. It then publishes coordinates and requests that later missions keep their distance. Each request rests upon plausible safety concerns. Over time, the operator controls the best route into the crater. Its equipment determines traffic patterns. Its communications schedule shapes local activity. Law follows the facts created by machinery. Possession will emerge through repeated practice rather than proclamation. States often accept a legal principle while competing over its practical meaning. The strongest actor establishes a custom through action. Partners adopt that custom because access depends upon cooperation. Rivals develop competing rules because dependence carries political cost. Lunar resource law will grow through this process. The United States has chosen a coalition model. It seeks shared standards among states that already cooperate in civil space activity. The Artemis Accords give this coalition a common vocabulary for extraction and coordination. That approach allows legal practice to develop before a universal treaty appears. It also places American launch capacity near the center of the emerging order. China and Russia have strategic reasons to favor another framework. A rival lunar project can establish its own procedures for access and resource recovery. It can define coordination through separate agreements. It can offer participation to states that prefer an alternative to American leadership. The legal contest then becomes a contest between operating systems for lunar power. Each system offers rules. Each system also creates dependence upon the infrastructure that makes those rules meaningful. The decisive advantage belongs to the coalition that reaches the surface and remains there. Diplomatic language gains force through physical capacity. A state that can land cargo on schedule can shape conduct around the landing site. A state that can provide navigation can shape the terms of access. A state that can rescue crews can earn authority through service. Courts may refine the rules. Hardware will establish the first grammar. This reality gives corporations a geopolitical role. A company that mines lunar ice will operate under state authorization. Article 6 ensures that private conduct remains tied to public responsibility. The company may hold contracts and property rights. Its machines will still extend the reach of its home state. Corporate activity, therefore, becomes a method of national presence. The home state gains influence from every successful mission. It gains technical knowledge about the terrain. It gains leverage over partners that need fuel. It gains a stronger position in later negotiations because its preferred rules already govern real activity. The company receives commercial protection. The state receives strategic depth. Private enterprise carries national power into a distant frontier. Resource ownership will also shape military planning. Lunar fuel could support movement throughout cislunar space. A dependable source of propellant may lower the cost of repositioning spacecraft. The state that controls production can support civil missions while building experience relevant to security operations. The same infrastructure can serve more than one purpose because physical capability carries several political meanings. This gives legal definitions great strategic weight. A narrow definition of extraction rights favors operators that can arrive early. A wider international management structure favors states seeking collective authority over access. A system built around first possession rewards speed and capital. A system built around shared administration rewards diplomatic numbers. Each legal model distributes power differently. The Moon Agreement offers a collective vision by treating lunar resources through the concept of the common heritage of mankind. It also anticipates an international regime for exploitation. Its modest adoption has confined its practical reach. The treaty still reveals the enduring alternative to national licensing. Future disputes will likely center on interference rather than formal sovereignty. One mission may approach a site reserved for active work. The resident operator may demand greater separation. The approaching mission may invoke freedom of exploration. Both sides may cite the Outer Space Treaty. The argument will concern dust or radio traffic. Beneath that argument lies a harder question. Which actor possesses authority over conduct near valuable resources? The answer will emerge from power supported by legitimacy. Force creates command. Legitimacy creates endurance. Durable authority requires both. The leading space power will therefore seek partners and publish standards. It will offer access while reserving command over the systems that make access possible. This is how legal leadership becomes geopolitical leadership. Lunar law will grow around the first functioning mines. Every successful extraction will strengthen one interpretation of the treaty system. Every coordinated landing will establish another precedent. Each safety zone will test the boundary between operational protection and territorial control. The coming legal war will take place through licenses and technical standards before it reaches any tribunal. The states that prepare early will write the customs of the moon. They will fund landers and operators. They will connect domestic law to international agreements. They will ensure that private firms serve national purposes. Their legal claims will carry weight because machines on the surface will give those claims a place to stand. The moon will remain a celestial body under international law. Its resources will become instruments of earthly power. The nations that understand this distinction will shape the lunar order. Other nations will inherit rules written by stronger hands.